Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about day school class actions. Cases that should have gone to the Supreme Court of Canada, but didn't. Joan Jack, among other individuals, commenced an action using a certain law firm in the Manitoba Court of Queen's Bench against Manitoba on the basis of the day school program. Eventually, she and the other plaintiffs in the class action discontinued their claim and discontinued their retainer with the original law firm. They then retained a second law firm, Gowlings, in order to file a class action in the federal court. After they were successful in reaching a settlement, the original law firm applied to the court for their legal fees related to the claim from the Manitoba Queen's Bench to be detracted from the amount of the settlement that was given to the original individuals as a result of unpaid legal bills, and they were successful in obtaining these funds. This case went to the Supreme Court of Canada seeking leave, which was denied. And this case raises important issues because it expands the scope, essentially, of the ability of law firms and lawyers to seek unpaid legal fees for legal work done in another action, in another forum, if there is a judgment that's obtained in these circumstances. And it feels particularly oppressive because it was a judgment related to, specifically, the day school program. There are also concerns about the actions that were taken by the law firm, given that the original action was filed in the Manitoba court when, because it related to a day school class action, it should have been originally filed in the federal court. So whether the legal work that was undertaken by the original lawyers really could have resulted in any outcome that was favorable to the plaintiffs was also questionable. And yet somehow they were able to recoup their legal fees. This, to me, seems to be the type of case that the Supreme Court of Canada should chime in on, because even though I'm a lawyer, the scope of lawyers' ability to collect money for work done on something completely different, effectively, in litigation through somebody else's other successful litigation in another court, in a completely new action, is something that is concerning. Giving lawyers too much power, and this would apply to any potential collector or creditor, giving them too much power to obtain money from funds received in settlement might also dilute or impair the settlement process. After all, these people were survivors of an absolute atrocity. And should they really have the money that they're due for having gone through something so horrible deducted to pay a law firm that didn't ultimately get them the settlement they want and didn't even file in the court that it should have been filed in? This to me seems like a very concerning method of enforcing a lawyer's right to collect legal fees for work done in a case. Ultimately, the Supreme Court of Canada should have chimed in here because there are certain aspects of reconciliation and oppression of Indigenous peoples that are concerning about this case, and whether or not that was what was going on, the Supreme Court of Canada should have taken the opportunity to clearly delineate what rights lawyers have and where those actions go too far. And it's unfortunate that they didn't in this case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenbull Creative for putting together these videos. Please like, subscribe, and share with your friends.